This is another Thirsty for Knowledge Thursday, brought to you by the Aries Foundation for Financial Education. And tonight we are doing Do I Need a Will? Or subtitled, Who's Gonna Get My Stuff When I'm Gone? When we say an estate plan, but really about, getting a will, right? So, the idea of having a will, honestly, if you're married, you should have a will. If you have children, you need a will, right? If you have real estate or actually any assets whatsoever, you need a will. So one of the documents that you should have, and I will make note of this, that for a lot in today's world anyway, right? We're talking 2021 now, that if you go to any attorney to get a will, that more than likely, along with that, some of the documents that we're going to talk about here, which is this advanced healthcare directive or a healthcare proxy and durable power of attorney, are all part of the package. Like, they don't let you walk in and only do a will today. And the idea here is that the likelihood and possibility, in fact, we're having this conversation today with somebody about, what happens later on, right? When I become unable to sort of advocate for myself, right? If something happens to me, if I become incapacitated or I become disabled, I can't advocate for myself, what do I do? And that's really where the power of attorney comes in. So the power of attorney lets somebody basically act on your behalf when you are unable to. And, like I said, one of the document with that is basically called a general durable power of attorney, DPOA, which just means that, it gives another person the opportunity to manage on your behalf financial affairs, property, anything should you become incapacitated, right? Right. And so now, just to get a little confusing with this, because you have the power of attorney for healthcare, right? Which, again, every state's sort of different in terms of how they word these, in terms of setting this all up, healthcare proxy, advanced directive, living will, all of these different things. We'll talk more and more about this, but it's basically, giving somebody, like we talked about here, in Massachusetts, it's a healthcare proxy, but this is giving somebody the ability to make that end of life decision for you. If you have a DNR, this is if that's your wish, then this would be the person who would be saying, do not resuscitate.
Well, the other reason this is important too, Tom, is because a lot of married couples think that just because we're married, I can sign for my spouse. And especially if they're incapacitated, I can just make these decisions. That's not necessarily true. And if God forbid, your spouse was in a position where they were, incapacitated for a long period of time, and let's say most of the assets are in their name, especially if they're retirement assets, you may not be able to make withdrawals or move money if you don't have that power of attorney.
Right.
So if it puts you in a real bind, you don't have that in place.
Yeah, absolutely. And it sort of goes hand in hand with the next one, which is basically talking about conservatorship, right? And, the big one that's in the news right now, if you followed it all, is Britney Spears. This becomes, a legal battle, which obviously is what's going on there with her in terms of dealing it. But this is a situation where you are saying the person in the case of Britney Spears, is unable to handle the management of their own finances. Without having a will, a court decides where your stuff is going. Now, if you're married, everything can pass to your spouse, but without a will, if there's kids, then pieces go here, pieces go there. And when you get into a situation where you might have, a multi-family, divorce, remarriage, other pieces, now you're getting into a whole big, mix there that's really going to cause a problem. it controls the disposition of your assets. Let's face it, it's a legally binding instrument, right? You put it together and you basically say, this is what I want to see happen.
Just so you're aware, this is not like a trust that avoids probate altogether. This is still a probatable event. If somebody wants to say, well, I'm contesting the will or I have a claim, they can still do that. Still has to go through a probate process. But what it does do is, if it does get in front of a judge, it says exactly what your intentions were. So they can't say, well, he meant to give me the car and the house.
And if you're trying to avoid state or any type of tax issues, without a will, it's definitely not going to happen. Different ways of leaving money or giving money to your kids, so you have the Uniform Gift to Minors Act, that's an UGMA. This is how money transfer was dealt with for a long period of time. It's avoiding your taxation because it gets taxed at the minor's rate. And a lot of people were doing this for education funding. I'm putting the money into an UGMA because now it's out of my tax bracket. It's now in the kid's name. And then the issue is when the kid reaches age of majority, which depending is somewhere between 18 and 21, it's their money. And they can do whatever they want with it. That means flat screen TVs and trips to Hawaii, and they don't have to go pay for college if they don't want to with that money. Now, you hope that they would, but that's one of the issues with an UGMA. It talks about the will and a family trust, right, in terms of leaving stuff to the kids. But guardians, right? So this is what we were talking about before. Guardianship, especially when you're dealing with minor children, yes, if you're married, your spouse is going to be the guardian. But if you're single, a single parent, or, whether it's divorce or widow, or both of you pass at the same time in an, unforeseen accident, then you need somebody who's going to take over raising your kids. The estate is a different story, but the estate is because somebody cannot, a minor child cannot manage the asset.
And then, some people go to the trust, the court to try to break that, but, all things that you can put in place. So you have a lot of control over your assets you can trust.
Yeah, absolutely. So then when we talk about titling, the home, because this is another one of those major assets that everyone has, right? So, not too much to do with the will, but just understand that, a lot of times if you're buying property, you want to make sure who's on the deed and, realize that you are responsible if you are on the deed. This happens a lot in divorce, that you can wind up in a situation that, if there's debt or something that's owed on there and you're on the deed, it's your responsibility too. So if you have an estate that is worth less than $11.58 million, you're not paying any federal estate taxes.
You're paying federal, you may be paying state.
No, it's federal. That's
federal estate taxes, right. Okay.
Federal estate taxes. However, understand that all of this stuff is going to sunset. And so, but there's no tax if you're married and you're passing it to your spouse. It's what's known as the unilateral marital deduction. So I can just, married, I pass everything to her, she passes everything to me. However, when I die, if that's the case, that's when all of that stuff comes into play. So a living trust, the idea here is that this is setting up for, I'm controlling the asset while I'm alive. There's really nothing that happens because everything occurs upon death. So basically your options are to do nothing. All right. Just let the chips fall where they may. We talked about this earlier today with somebody. You're going to live forever. Okay, so you never have to worry about any of this stuff because you're never going to die, right? Not really the best of plans, not really good options for family, for loved ones, for taking care of stuff. It really is not that hard or long of a process to deal with, especially if you don't have a lot of stuff. And it's just mainly cleaning things up and making sure who's taking care of the kids type of thing, but the mandate is get it done, right? That's create the will, maybe look at creating that, depending on your situation, that other trust or other arrangement in terms of making sure, everything is together.
Have questions? Ask us. We can help with that. You can email Craig at crichardson@aresfoundation.org, or you can visit the website to learn more about what we do and how we might be able to help you. www.aresfoundation.org. Want to see more of this recording? Go to www.aresfoundation.org/events. If you know an organization or community support group that could benefit from one of our workshops, reach out to Tom T. Alessi at aresfoundation.org. Our mission is trying to help everyone have a better relationship with their money.